Excellent. So welcome everyone. Thank you so much for joining us this afternoon for Wills and Estate Planning, Learning Exploration from the Family Support Institute. My name is Karen Speyer. I am a Regional Network Coordinator with the Family Support Institute for the Fraser South region. And for those of you that are joining us here this afternoon that are not familiar with the Family Support Institute, we are a nonprofit society made up of a network of volunteer resource parents from across the province. And I personally today would like to acknowledge that I'm coming to you virtually from the Coast Salish lands, the unceded territory of the Katsikwantlen and Semiahmoo First Nations, today known as Langley. It was 23 years ago that I was introduced to the Family Support Institute through the needs of the peer-to-peer support model that we offer. My youngest son was born with Down syndrome, and like many of you, I was looking for answers and looking for support. And I was so privileged to be introduced to one of our volunteer resource parents that was able to provide that peer-to-peer support model. We're a grassroots organization. We provide all our services and supports are free to any family across the province. We have many wonderful presentations such as this that we're hosting here today to help bring those supports to people. If you would like to learn more about the Family Support Institute, I will put our website into the chat box so that you can contact us and see many of the supports that are available. Before we get started, I just want to let you all know that this is a safe and secure place for conversations. Everything that we talk about here is held in confidence, so please feel free to ask the questions that you feel comfortable in asking. At this time, I'd like to introduce you to Bob Kashup, who is going to be the host for our presentation here today, and he will then introduce our guests. So Bob, over to you.
Thanks, Karen. Welcome, everybody. It's an honor to have you guys on this learning exploration from FSI. I am a staff member at FSI. I'm a coordinator for family support, and I'm coming to you from Coquitlam, where I live. I would take this opportunity to introduce our very distinguished speaker, Mr. Ken Kramer, who is the founder and principal of KMK Law, a boutique law firm in downtown Vancouver. He specializes in estates, trust, administration, elder law, estate litigation, and mediation, and has been doing so for the past 25 years. He has a unique understanding of the disability community combined with the expertise in the area of estates and trust law to serve families with disabilities. There is a lot on the screen. I won't read it all, but I must just let you know that we are honored to have him speak today and share his wealth of knowledge and information with all of us to help us provide better for our loved ones. Our other speaker who is accompanying Ken today is Audrey Jin. She's an associate at KMK Law, and she also specializes in estates and trust matters to serve families with disabilities and their unique needs. So again, I will not read everything on the screen because you can see for yourself how distinguished she is too. And I would just recommend that please keep your questions ready because they are here to answer to the best of their ability whatever we might need to clarify at this point in time. So with that, I will hand you over to Ken, and he will take it on from here. Thanks so much.
Good afternoon, and thank you, Bob. I appreciate that kind introduction. Audrey and I are just so pleased, as usual, to be able to contribute to the great organization of FSI and all your members. So we thank you and your team for this invitation and the opportunity to provide a little bit more education and hopefully a bit more of a foundation of knowledge when it comes to estates and trust planning, but with a real disability focus. So I'm going to kick things off. And Bob, thanks for raising the issue of questions. I know there are already some questions that are coming into the chat. Please keep those questions coming in. I'm going to suggest, in the efficiency of time, that we try to run through our presentation to the best of our ability and leave ample time at the end to answer as many questions as we can. And my hope is that during the session, some of those questions may even be answered in the context of the materials that we're going to run through. So I wanted to start with a bit of an outline for today's discussion. And we're going to focus really on 4 areas, really. And the first one, of course, is disability benefits in British Columbia. That is, generally speaking, what is an initiator for folks to start thinking about estate planning. And obviously, preserving benefits is a priority for many families where there is a loved one with a disability that's receiving provincial benefits in our province. A big chunk of the presentation is going to be focused around estate and trust planning. So the different vehicles that we have when planning for that loved one with a disability. And there's going to be a real focus there on trust development and the various trusts, and trying to ensure that everybody really understands that interrelationship of trust law and disability. And then the third item that I really want to focus on, and it's a challenge for many families, once we undertake the initiative of planning, one of the biggest challenges is actually determining who is going to manage all this when you're not here, who's going to execute the role of trustee. We're also very fortunate in that we're living in a time where we have a number of vehicles, estate planning vehicles outside of trusts. And so from a planning perspective, it's also really, really important for us to look at some of these other planning tools that might supplement or be utilized in addition to the trust planning. And then finally, we'll leave you with some resources, that will hopefully help further enrich your understanding of this very important topic. So, as I had said at the outset, one of the main reasons why we start to look at estate planning is that when our children turn 18, they're potentially eligible for provincial disability assistance. And these are the benefits, the monthly fund that is provided by the ministry for somebody that is eligible for provincial benefits. I should add that provincial benefits is much broader than just the monthly income that they might receive. There are a number of other related benefits that the ministry will provide, as will other ministries within the provincial government. So when we're thinking about resources from the province, it's much broader than just, an income. There are prescriptions, there are medical costs, there are home care related costs, as well as, of course, education and labor initiatives. So a number of items. But for our purposes, provincial disability benefits is an important factor in estate planning because it is an asset tested benefit, but it is also an income tested benefit. And so in order to qualify for provincial benefits, you must meet certain financial criteria. And this list here that I'm going to outline is not exclusive. There are a number of other interrelated benefits and limitations on provincial disability benefits. But by way of highlight, an individual receiving such benefits is able to have up to $100,000 in liquid assets. I should note that amount many years ago used to be $5,000. So it's come up significantly over the last several years. It's a significant amount of money, but it is a threshold. And if you exceed that $100,000, that individual receiving provincial benefits will no longer be entitled to benefits. You can also own your own vehicle. And for many families, homes are really important. And so you can actually own a principal residence. Now, I'm not going to get into a lot of detail on the interrelationship of buying a home because it's a very complex area. And I know that I've actually been in discussions with FSI, and we're going to be doing another session later in the year on home ownership and the issues around and the challenges of facilitating home ownership where there is a person with a disability. But for our purposes, a principal residence is an exempt asset and there is no dollar threshold. You can have a principal residence that is millions of dollars and your loved one with a disability will still qualify for provincial disability benefits. So part of the process of planning involves having a will. And of course, many individuals do not have a will. And that's where we run into a lot of problems. So a lot of this discussion is going to focus on the benefits of having a will and the flexibility that is incorporated within the will that will enable you to provide for a loved one with a disability and still provide a lot of protection. But we thought it's important for everybody to understand what are some of the consequences of not having a will. So in British Columbia, if you die without a will, you're obviously unable then to determine what your wishes were. You're now in a situation where you're subject to intestacy legislation. And this is where an individual without a will would basically die intestate. And there's a law that outlines how your estate would be divided. So this law effectively has been developed by members of our government, and they have made some decisions about how your estate will be divided if you're not around. And it's very much based on family lines. So for example, if you die with a spouse and children, a portion will go to your spouse, a portion will go to your children. You don't have the ability to provide for charities. You don't have the ability to develop a trust for a loved one with a disability. So it's a very archaic distribution. And one of the big, I guess, concerns of dying intestate is that if you don't have a will and you haven't planned for that loved one with a disability and you're relying on this legislation, you may actually create more problems for that person with a disability by not having a will. So there are other ramifications as well, because in British Columbia, it's not uncommon for estates to be more than $100,000. So if you die without a will, again, this could have impacts on that person receiving provincial disability benefits if the amount they receive under that intestacy legislation exceeds $100,000. So right away, you've created a potential, challenge around someone receiving provincial disability benefits. The other thing that's really important to note as well is that within a will, you're able to also appoint guardians for minor children. And so again, I'm not talking about adult children. I'm talking about minor children. And a guardian would be appointed within your will, expressing your wishes with respect to who you might want to have custody of your children when you're no longer here. And this is really important because if you have not made a provision for minor children, there is a possible risk that either the Ministry of Children and Families or the public guardian and trustee of British Columbia will have conduct either of the custody of your children and or the estate or the inheritance that those children might receive. For many families, this alone is reason enough to develop a will, because who knows and who understands and who's able to provide for your children better. And that is not government. It is family, it is friends, it is people that you know and trust. So a will help avoid this possibility of government playing a role in the management of your family. Okay, I'm going to turn things over to Audrey, and Audrey's going to touch on a few important issues of trust and disability.
Thank you, Ken. What Ken mentioned about some of the questions being answered as we talk, I noticed one question in the chat which asked essentially, how do you leave funds for your children? I think I'm paraphrasing here, without affecting their disability benefits. And that's really the crux of our presentation today. As Ken mentioned, for a person who's receiving PWD benefits, they have that asset limitation, so they can really only have $100,000 that they're holding on their own, as well as some other exempt benefits like a principal residence or a car before their PWD benefits start to get affected. However, if you create a trust within your will, and that trust is properly structured and planned for, that is a really effective vehicle for you to plan for your child or somebody else that you're planning to leave funds for who is receiving those PWD benefits. Not only are you able to likely preserve their eligibility for benefits, but it's also a huge asset, especially when that person can't manage that money for themselves. So if you create a trust in your will, you'd be appointing a trustee who is essentially the person who will be managing those trust funds for the benefit of the beneficiary of the trust, who is that person with a disability. So number one, that person will help them manage their money. They'll do the investments and things like that to make sure that that money doesn't sit idle or depreciate in value. And it will also protect them, especially if that person might have a higher level of susceptibility. Like maybe they have friends who might ask them to loan them money and they'll go, sure, I'll do whatever you want. And this having a trust where their funds are kept and it's managed by a trustee who you trust provides a layer of protection for those kinds of issues. And the last point on the slide here again, which we mentioned, is we have that preservation of provincial disability benefits, which is often one of the most important things that our clients come to us with as a concern. Something else that we wanted to talk about is the other benefits of having a will. So one key benefit, obviously, is that a will gives you control over your estate. As Ken mentioned, if you don't have a will, your is that you essentially you're essentially said to have died intestate, which means again that it falls into the default legislation and your estate will be divided as the law says. However, with a will, you can make several choices. So for example, you can choose to appoint an executor of your choice to manage your affairs. And what the executor does essentially is after you pass away, they gather everything that encompasses your estate and they have to apply for a probate of your will, which essentially just means that they're taking your will to the court to say this is your valid last will and these were your final wishes. As Ken mentioned, you can also appoint a guardian for any young children that you have to make sure that the person or persons of your choice have that ability to look after them until they hit the age of majority. And most importantly, you can distribute your estate in the amounts into the persons you wish. Perhaps you have close friends or a particular charity that you're passionate about, and you're able to do that through a will. And finally, as we mentioned, the will gives you the ability to create those trusts to protect certain beneficiaries, maybe not only individuals who have disabilities, but sometimes people create something called spendthrift trusts. For example, if they have a child who has issues with managing money, perhaps they have what's called traditional capacity, but still you're not sure that they'd be able to manage, $100,000, $200,000 really well. And so you want to create a trust for that person. A very important thing as well is something called wills variation. And often people don't know what this term means, but you might understand it as challenging or contesting a will. So we'll often get clients who come to us who say that, oh, I'm estranged from X or Y person. I don't want them to challenge my will after I die, and essentially make the whole planning process moot. So under the law in BC, there is a legal and moral obligation to provide for your spouse or your children. So for example, if you completely disinherit your spouse or one of your children, those individuals can challenge your will in court through a wills variation claim. And it doesn't even have to be complete disinheritance. Let's say you give one child, $5 million and you give the other one $10. They still have that ability to challenge that in court. There is a deadline. They have to do it within a certain number of days, but they have that ability. That could be subject to change in the future. There are some cases in court in other provinces in Canada that are challenging this ability to challenge the will, saying that the will maker should have the autonomy to make decisions as they wish, but this is the current state of affairs at this time. Something that individuals used to do in the past is they would say, oh, my disabled child can't manage this money. They might not even need this money. I'm going to give nothing to them, or I'm going to give this money to my sister, my child's aunt, and they'll be able to look after my child. But it is important to, in the view of wills variation, to make sure that you've made an appropriate share of your estate for your disabled child. So if you end up leaving nothing to them, or you leave a very reduced amount to that child, a court has the power to very meaning change your will and order that that person with a disability receive a larger share of your estate. So what happens when somebody who has PWD designation is a beneficiary of an estate is that the PGT is usually notified. They're told about the will. They're told about, they're given a copy of the will, and the PGT may say, hey, I see this person's not getting anything. This seems unfair. We're going to bring a claim on this person's behalf to the courts and ensure that they get their fair share.
Audrey, not to interrupt, but there was a question on this particular topic in that, does this work the same for someone living common law?
So if they're considered a spouse under the legislation, then yes, they would be considered a spouse, and then they would have the ability to vary the will as well. And there's some really interesting cases on that. But yes, that's definitely a possibility.
Yeah, and just to add to that, spouses are defined very broadly. So, in our province, in our country, obviously the traditional spouses, there's common law spouses, same-sex spouses. In fact, one could have potentially multiple spouses under the legislation scheme. So there is indeed a lot of interesting case law around the definition of a spouse and the broadening of that definition. In fact, there's some recent case law that suggests even somebody not living what we consider sort of that traditional common law relationship, living separate and apart, may still be perceived as a common law spouse, even with separate residences. So it's a great thing for estate litigators, but it's a bit of a nightmare for planners. So Audrey has really outlined, I think, why a disability trust is such a great vehicle. And obviously, that preservation of provincial disability benefits always is a priority. But I find more and more that, it's more than just benefits. It's typically also looking at the individual with a disability and, providing protections and oversight against vulnerabilities and undue influence. Having that friend suddenly appear and asking for money. So we want to be able to not only preserve these benefits, but we also want to protect our loved ones with disabilities and ensure that they're not being put in a difficult situation, either because of an inability or incapability to manage funds, or whether there may just be simply incapacity to manage an inheritance. So the trust, serves a number of very valuable purposes in the design, and notwithstanding some of the other tools that I'll touch on, Audrey and I will touch on today, the trust is still, I would say, the primary vehicle in the estate planning world when it comes to disability and estate planning. So,
Ken, just a quick question on that before we carry on. We've had a couple of questions that deal with this particular topic. One of the questions was, is it possible for someone who is involved with the PGT or has a representation agreement to make a will? They would not be considered legally competent, most likely, which is why there's supported decision-making in place.
So in developing a will, Karen, the primary criteria is that an individual must have capability. And the test of capability is not necessarily one of a medical test of capability. It's one of a legal test. And so a lawyer like ourselves would go through an interview with an individual to determine whether they had capacity to actually develop a will. So it's a bit premature to conclude that this individual that might have some oversight of the PGT, and again, it depends on what that oversight is. But I think the key point is that it's an individual sort of assessment, and the only way to determine whether someone has capacity, of course, is for that individual to meet with a lawyer like myself or Audrey to assess whether they would meet the test of developing a will for themselves. And I guess that's why I think it's really important not to sort of conclude with certainty that someone may not be able to do a will. I think it would be unfair and unrealistic to make those conclusions. without them having had that opportunity. And I know I've done some such sessions for other groups where, we've also really looked at circumstances where, we try to look at the possibilities of an individual, even with, a diminished level of capacity. If they can meet that legal test, a will is definitely possible. Now, of course, if somebody is subject to committeeship, which is effectively an order of the court saying that they do not have capacity, and there is a representative that has been appointed, then of course that committee would not be able to develop a will for that individual. Now, a representation agreement is more of a supportive tool. So again, it doesn't sort of broaden the scope of authority to include the development of a will. So, but it's a great question, Karen, and it's one that I see more and more. And again, I think it's always reasonable to conclude that, if someone has that ability to develop a will and they have assets that they want to distribute, that, there's some onus on an estate lawyer like us to do our best to try to achieve those goals. But at the end of the day, we need to be satisfied as well that they have that capacity. I know one of the questions that also popped up in that area is, well, what is that test? So there's a long-standing legal test of, capacity to develop an estate plan. And, and effectively, I think what we look for is, does number one, the individual understand and appreciate what their assets are? Do they understand their liabilities? And are they comfortable and appreciative of what it means to appoint an executor to manage their affairs when they're no longer here? And are they able to comprehend their responsibilities under estate laws? Audrey mentioned wills variation. Are they appreciative of the obligations they might have to a spouse and or to children? Are they cognizant of what it means to provide for one person versus another person? So it really is a discretionary individual decision that's best left to the lawyer and the client when they're actually determining whether a will is something that can be developed.
Thanks, Ken.
So obviously, we've talked a lot about the benefits of a trust. And I think it's important to also reflect on what is a trust. So we're going to run through that a little bit now. And so, at a very basic level, a trust is a relationship where one person, who we call the settlor, gives assets to a second person, and we call that person the trustee, to hold and use for the benefit of a third person that we call the beneficiary. And this is typically the person with the disability. So within the context of trust vehicles, there are some distinguishing features that I think are really important to understand. And I think these are areas where folks get a little bit overwhelmed, a little bit confused. So we're going to try to take this nice and slow to ensure that people understand and appreciate these different vehicles. So the first thing I will talk about is that there are effectively two types of trusts. There are trusts that are called inter vivos trusts, or these are living trusts. And then there are testamentary trusts, or trusts that we call a death trust. The difference, of course, between these trusts is how they were created, and from a tax perspective, how the income within the trust is taxed. So with that inter vivos trust or that living trust, these are typically created by a person while they are alive for their own benefit or for someone else. A good example of these trusts are situations where no trust planning has been done. And a great example of this, because I see this quite a bit, is where grandma perhaps has left an inheritance for their son or daughter with a disability and obviously did not attend the FSI workshop on estates and trust law. And as a result of that, although they were very much just thinking of their granddaughter, they left $200,000 to that granddaughter, but no trust. They had no idea that disability benefits were in play. And so now grandma has passed on and the family is in a bit of a panic. How do we resolve this now without losing benefits? And this is where the inter vivos or living trust can be created after the fact. So after the passing of grandma, to hold those assets in a trust for the benefit of granddaughter and still be able to maintain benefits. Audrey's going to touch on that a little bit more on the difference, the distinctions of the different trusts within that inter vivos trust. Just go back one slide, Audrey, okay? And then the other trust, of course, is that death trust, which is the more common trust that we see. And this is the trust that all of you as attendees of this session are going to be thinking about in your estate plan. And these trusts are actually only implicated when the person passes away. So when you die, the trust would then be developed to hold an inheritance generally for a person with a disability. Now, I should add as well, the other thing that's really important to distinguish on these trusts is the issue of taxation. And, you know, I don't want to get into a great detailed discussion of taxation, but tax is relevant. And it's one of the factors that need to be considered in trust law. One thing I will say is that when you have a living trust or an inter vivos trust, the income earned in that trust is always taxed at the highest marginal rates of tax. So from a tax standing perspective, it is at a very high rate. The testamentary trust or the death trust, however, could be taxed at the lower marginal rate of the person with a disability, assuming that that person with a disability meets a myriad of criteria recently announced by the federal government so that that trust is deemed to be a qualified disability trust. So if you meet that criteria, and one of the criteria is that the person with a disability must be eligible for the federal disability tax credit. If that credit is in place, that trust and the income earned in that trust may be taxed at lower marginal rates. You know, and years ago, we never really touched on taxation because there was always a perspective that preservation of provincial benefits and protection from vulnerability and undue influence ranked higher in priority. And I think for many families, it still does. But I think it's important to understand that there are tax ramifications from having these trusts that somehow may be seen as a negative in terms of the planning. But, you know, as with any investment, with any vehicle that we're looking at, there's always going to be sort of a trade-off of benefits. And I think it's important that whenever a family member is looking at designing a trust, that they have the full benefit of all of the benefits and the costs associated with those vehicles. Okay, over to you, Audrey.
Thanks, Ken. So as Ken mentioned, there are also different types of trusts. He talked about the difference between inter vivos, aka living trusts, as well as testamentary or death trusts. But there is a provincial policy manual that you can find if you just Google like BC Trust Policy Manual, and that talks about two other types of trusts. They're called the non-discretionary trust as well as the discretionary trust. And what non-discretionary and discretionary really mean is that they describe what kind of control and power that the trustees of the trust have in managing the assets of the trust. So how much discretion do they have? So in non-discretionary trusts, the trustee does not have total authority over how the assets are managed. For example, the beneficiary might have some kind of input in the decision-making of the trust, either because they might be, for example, the only trustee as well as beneficiary, or because they originally contributed the assets and there's still some kind of level of control over them. So non-discretionary trusts are considered exempt assets. So as long as the value of the capital contributed to the trust does not exceed $200,000. So that's $200,000 on top of the $100,000 that that person can have outside of a trust. However, if it's a non-discretionary trust and the person wants to contribute more than $200,000, that any amount above that is not going to be exempt as an asset unless you apply for special approval by the minister. And in that case, what would happen is you would send in an application sort of outlining, including medical reports saying how this additional funds are needed to pay for disability related costs. And in that case, you may be able to get that exemption, but it's definitely not a given. On the other hand, we have something called discretionary trusts. Also, you might have heard the term Henson Trust. The word Henson comes from a court case out of Ontario, where this was really first recognized by the Ontario courts. So on the other hand, a Henson Trust is an absolutely discretionary trust in nature, and it really leaves the distribution of the income and capital of the trust at the trustee's complete discretion. So the real benefit of this type of trust is that there's no sort of limit. There's no $200,000 limit. There's really no limit at all. So you could have millions of dollars in there and it would still be considered exempt. So it wouldn't be considered an asset under the disability legislation in BC. So essentially the reason why is that they don't consider it an asset of the person with a disability is because that person has no input as to how much the trustee will pay to them or pay for their benefit. Because they don't have any control, the disabled beneficiary does not have that quote unquote beneficial interest in assets held in the trust or right to income in the trust, and therefore they can't be said to have any right to any of the capital. So there are also some issues to be aware of when you're creating a discretionary trust. So, I mean, obviously, the number one thing is who it's for. I think all of you would likely know that, but there are some other things to take into consideration. So, for example, are there going to be any beneficiaries in addition to the disabled beneficiary, during that person's lifetime, or if that beneficiary passes away? Who are the ultimate beneficiaries going to be? You can also note in there that regardless of the fact that there are other beneficiaries in addition to the disabled beneficiary, that the trustee doesn't have to follow that even-handed principle. And the even-handed principle is one in trust law that essentially says that the trustee, when making sort of decisions between income and capital beneficiaries, has to kind of take into consideration each beneficiary's needs. But we find that most people who come to us wanting to create a trust really have that one principal disabled beneficiary in mind. So they want the trustee to be able to do whatever with the money as long as it's in that one disabled beneficiary's interest. And so generally in our case, we see that the will maker or the settler preference is to have that even-handed principle not applied to the trustee in that case. You'll also want to be aware of the collapsible discretionary trust. So this can cause eligibility concerns if, for example, the beneficiary has control over the funds before they are placed in the discretionary trust, or if the amount contributed to the trust is more than $200,000. And the other thing, finally, to be concerned about is if the beneficiary has a legal right to collapse the trust and gain control of the assets, the ministry may consider the trust to be an asset, again, which may impact eligibility for provincial benefits, depending on the amount in the trust. I'll now turn it over to Ken to talk about permitted expenditures.
Great. Before I do that, I just want to, Karen, just check in, because I know that's a lot of information, and I just want to make sure everybody's following it. If there's any questions about the trust concept.
Yes, we do have. I've been copying, pasting them onto a document, and I wasn't sure where you wanted to discuss those. So if I
might be a good time to do it now, yeah.
Okay.
While it's fresh in everybody's mind.
The first question we received yesterday actually was if we could touch on wills and estates with special needs adults where the adult goes back and forth between mom and dad's home. Ex-wife and I share custody, and our daughter will be 19 in a year and a half. I realize things will change when she is 19 from a legal perspective, but was wondering what needs to be done from a will estate perspective.
Well, I mean, I think, as I think we've kind of highlighted that, there's this ongoing duty and obligation for parents, adults, anybody that has an estate to plan for their family. And Audrey highlighted some legal reasons why the will's variation rights, for example. Obviously, when you have minor children, the needs and the responsibilities are different. But for people where, there is disability, although that person might turn 19, much of the dependency might still be in place over that individual. But from a legal standpoint, there's a presumption that when you turn 19, you are deemed to have capability unless there's evidence otherwise. And so, that responsibility, I think, is at a heightened level, I think, for families where disability is in place, because even when you go from minor children to adult children, to some extent, those responsibilities haven't changed. There's still that duty to provide and support that loved one, but the legal context around it is different. And that's where, a trust can serve a really valuable purpose, because it effectively will enable you to plan for that loved one, whether they are a minor or whether they are an adult. And as they become adults, their entitlements, their abilities will change. And it's important, I think, for a lot of families, by having a plan in place for when your children turn 19, it also opens up the door to avoiding, these last resort remedies, for example, of private comiteeship, to get guardianship of an adult individual. And I know I've spoken a lot on this, and we're going to do a session on May 3 for FSI as well on sort of personal planning and representation agreements, and these other vehicles that are out there to sort of provide supports once you turn 19. And a lot of the emphasis is not to automatically presume that comiteeship is the only answer. In fact, I see it as a last resort, option that is only necessary if certain criteria are met and there's a need for that. There are a number of other vehicles that we might pursue before we get to that stage. So I think that, the intention here today is to provide hopefully a little bit more of a foundation of knowledge for families, to really hopefully instill them with some confidence that there are solutions available. And it's a question of which solution works best for your family. And really, one size does not fit all. Everybody needs to be assessed on their own individual needs. And your family versus another family, maybe there are some similarities, but it doesn't necessarily mean that the same plan in itself is going to work for that family. So I think that's where getting some of this foundation of knowledge hopefully will provide a little bit more confidence and peace of mind that there are some solutions available.
That's great, Ken. And that actually kind of helps with a couple of other questions here from two other viewers. One is, how do you determine if they are capable? What's the criteria? And if a person doesn't meet the capacity criteria to make will, what happens then? Yeah.
And I think we kind of touched on that a little bit earlier around, what we as lawyers might look for in terms of assessing capacity, that sort of issue of, does the individual appreciate and understand their assets, their liabilities, the impacts of appointing an executor, what it means to provide for one beneficiary and not another beneficiary, understanding your moral and legal entitlements or responsibilities. Those are all really, really important. Obviously, if someone cannot do a will, they're left with what we discussed early on, which is, intestacy. So if you don't have a will, the legislation will then determine how your estate is distributed. So there is a backup. It's not ideal, but it is a backup where capacity may not be in place. And so there is that provision to distribute an individual's estate. The trust planning, though, and I think generally speaking, in the context of estate planning, the individual with a disability typically does not have great wealth unless they've been provided for through an inheritance. And it's the inheritance that we want to protect. And that's where the trust will help us avoid the need for concerning ourselves about whether that individual has a will or doesn't have a will, because the trust will effectively serve as a vehicle to provide for that distribution to that individual with a disability. But it will go beyond that, in that if something were to happen with that person with a disability and they passed on with funds in that trust, you as the creator of that trust would be able to determine who receives that fund after the person with a disability. And that may be another family member, a sibling, it may be a charity, whatever your wishes are. So you effectively, with a trust, are estate planning not only for yourself, but for the person with a disability that may not be able to develop a will.
And that's interesting, Ken. It leads right into the next question I have here is, I'm starting to see many of the folks who lived in Woodlands getting to the stage of their life where this is a concern. Most do not have family. They received Woodlands settlement that sits with the PGT. If they pass, the settlement goes back to the government if there's no family.
Yeah, I mean, and that's a genuine possibility. Obviously the intestacy legislation is based on, effectively a family tree. And where those individuals are not or do not have family and family cannot be located, that intestacy potentially could result in a fund being ultimately distributed to government, of course. And I think that's where, this presumption of capability, I think, is becoming more and more important. And, I think there's a duty on us as practitioners to not just make presumptions that somebody doesn't have capability. And I know we work really hard at, trying to achieve a client's wishes, but also appreciating that, we have a certain legal responsibility as well. But we do our best to, flesh out wishes and develop confidence that that person may have sufficient legal capacity. And I think that's really, really important in that it is not a medical test. We're not doctors. We're not here to make a clinical observation or determination. Our role is to apply, the legal test in assessing whether somebody meets the criteria to develop a will. And if so, there's a responsibility on us to help execute that plan.
That's great information, Ken. The other two questions I have are to do with RDSPs. Would you like to carry on the presentation, or would you like to answer those questions right now?
Why don't we hold on, because
Okay.
we're going to touch on RDSPs
Okay,
very,
great.
very shortly. But if we don't, Karen, you let me know, and
I
we
will.
answer that, okay?
Okay, sounds good. Carry on.
So now that we've got through the development of the trust, it's now set up. The next logical question, of course, is, well, how do we expend money out of this trust? And what is the duties and responsibilities of our trustees? And so what we're going to try to do is provide a little bit of an overview of trustee sort of do's and don'ts, and also some guidance around permitted expenditures from a trust. So what you have in front of you here is sort of a list of fund or expenditures that can be utilized from a trust. And I might add that this is really with a focus on preserving provincial disability benefits, right? And these categories are effectively taken right out of the disability benefit regulation, which is part of the ministry's legislation on this area. And you'll see here that, the types of items that can be expended for are things like caregiver services related to disability, education or training, home renovations due to disability, home maintenance, medical aids. Now, one of the things to note about these first 5 categories, and it's one of my frustrations with the legislation, and that is that if somebody is receiving provincial disability benefits, they're likely going to be entitled to a number of other government supports. Home care, for example. They're going to have prescriptions. They're going to have medical equipment that's available to them. So when I'm designing these trusts, I don't want my trustees to start spending money on items that are potentially available to that person with a disability through the provincial government. So we really try to outline a plan, understanding that our trustees may not be experts in disability legislation, but we want to give them some guidance, right? And so, what we try to do is we tell the trustee, you can spend on these items, but before you do that, you might want to first check and see if some of these funds could be expended or provided through government. And that's not to say you must do that. We're just suggesting that it should be something that's encouraged. And this is I think a growing concern as practitioners, because we're seeing policy development in government, which is to some extent starting to put some threat into these trusts. And there was a Supreme Court of Canada case about 2 years ago that touched on subsidized housing and a trust versus an entitlement to have subsidized housing funded from BC Housing, for example. And so it kind of raised the eyebrow of a lot of practitioners. Unfortunately, the law was clarified the way that we anticipated it would be, but it definitely left the door open for policymakers. So I think it's just important to remember that in these expenditures. But there is a final category that I touch on there, which is any other item that the trustee or beneficiary considers necessary to promote the person's independence. So the natural question is, what does independence mean? And the great thing about this is that the ministry has now said that it's not what we think is independence, it's what the trustee and the beneficiary considers to be independence. And so there really isn't a limit. And this category of expenditure is extremely helpful for trustees because it can basically be whatever is deemed to be necessary to promote independence. So an example of this, when we're actually able to fly and travel again, this could be a trip every year, to Hawaii and caregivers. It could be a membership in a fitness club. It could be tickets to a Vancouver Canucks hockey game. Really, there's no limit, aside from the pandemic, of course, on what these expenditures could be. So it's very, very broad. And I think one of the great things that government did a couple of years ago is they also eliminated the dollar limit that can be expended for this purpose. It used to be that you could only spend $8,000 a year. That limit is no longer in place. So in reality, one could expend the entire trust fund if necessary to facilitate those expenditures for independence. Okay. The other thing that I think is really important as well is that there needs to be an understanding and appreciation of how these trusts work in relation to the ministry. And again, we're talking about preservation of provincial disability benefits. And one of the number one challenges I see with trustees is they make presumptions. So for example, the trustee might say, can I just give the person with a disability, $1,000 a month? Let them do whatever they want with it. The challenge with that is that whenever the person with a disability receiving benefits receives a distribution from the trust, it needs to meet those criteria that I've outlined earlier. And one of the challenges is that if you give money directly to the person with a disability, the ministry considers that to be unearned income. And unearned income is actually deducted dollar for dollar from the person's provincial disability benefit. So you give somebody $1,000 a month, it's going to reduce their benefits by $1,000. And so that needs to be distinguished from what we call earned income. Earned income is actually employment-related income. So an individual receiving provincial disability benefits can earn, I know the numbers are changing, but I believe it's around $15,000 now annually. You can earn income from employment. So when the trustee is making disbursements from the trust, it's important that it fits within those expenditure criteria that I mentioned on the last slide. So if you give $1,000 to that person, it's got to meet one of those criteria. It needs to be classified as, for purposes of independence, and there needs to be some clarity. Otherwise, you run the risk that the ministry is calling it unearned income. My general preference is that the trustee not give the money directly to the person with the disability, but rather filter it through third parties. So for example, if there's a vacation to Hawaii, pay the travel agent, pay the airline directly, but then the person with the disability will not have touched the funds, and therefore they will not, it would not be considered unearned income in their hands. So that's a really high level overview, and it will help, I think, trustees in managing those trust funds. But more importantly, if you're going to go to this extent of developing these trusts, you're going to want to know that the trust is going to actually work, and it's not going to create more problems for the person with a disability. So those trustees, need to also get guidance, get advice. And those are permissible expenses as well for the trustee. It would be prudent for a trustee to go out and seek, independent legal advice so that they're making disbursements that don't actually create, challenges with respect to an entitlement to benefits. The other thing that's really important to note is that when the trust becomes effective, when it actually is in place and it's actually been utilized, anyone receiving provincial benefits also has a duty to notify the ministry that they have a trust and that it has been, what we call as lawyers, settled, i.e. the money has been put in the trust. There's a bank account set up. There's trustees that have been appointed and that they have signing authority. All of that information needs to be submitted to the ministry so that they can then review the trust and ensure that it is compliant with the regulations. And a lot of folks forget about that, but there is that ongoing duty to provide notice to the government that you have a trust and that it is valid and effective and in place. But remember, when you're creating a trust within a will, that will only happen when the person that set up that trust in their will has died. So you don't need to run out to the ministry the moment you do a will. It's when you pass away, when the trust actually is in place.
Can we have one question on the unearned income, if I could just intervene? What is the cap on unearned income? Is it $15,000 a year without it being compromised?
No, so unearned income, there is no cap. So unearned income is $1 is deducted from benefits. There's no limit. So anything that's considered unearned income is deducted dollar for dollar from benefits. Earned income, which is employment income has a cap. Again, I think the listener is correct. It is $15,000 annually that can be earned from, part-time employment.
Thank you.
I want to just also add that within that trust, assets can be quite varied. It can be cash, it can be, personal property, it can be even real estate. So a trust could hold a property that could be, again, utilized as a residence for a person with a disability. Now, as I mentioned earlier, we're going to do a session later in the year for FSI on home ownership and disability. And this is a real complex area. There are a number of tax issues that need to be contemplated. So I would suggest don't run out and put a house into a trust until you get some really good legal advice, and ensure that by making that decision, you're not creating some unintended consequences. The other thing I'll just touch on really briefly is that, in the context of an estate plan, individuals will have other assets. So, very common for spouses to have RRSPs or RIFs, life insurance. And within those plans, they will have designated beneficiaries. And it's very common for spouses to name each other as the initial beneficiaries. But what is important as well, and this is more from the context of estate planning, and that is when you designate a beneficiary, the benefit of that asset will not go to your estate. It will go directly to the party you designate as the beneficiary. So if you decide to designate a son or a daughter with a disability receiving provincial benefits, the trust planning that you do in your will not cover that designation. So it's very important in the planning to understand all of your assets and ensure that there's an appreciation and appreciation of the impacts of a designation. Because if you designate that person with a disability, they're going to receive that money outright, outside of your will, outside of any trusts that we may have developed. And if there's provincial benefits in place, or there's capacity issues, or an inability to manage money, that will basically undo that planning. So carefully consider those designations and how you make them, especially where disability is in place. So the other thing that's really important is, and today I mentioned, we have all these different vehicles around us today. And so, from a planning perspective, we're kind of blessed in that we have a number of options available that, we can consider. So we always need to consider, is the trust the best option available? What's the cost benefit analysis of that trust? Are there other exempt assets that we might want to consider or utilize instead? We need to think about the personal circumstances of the person with a disability, the beneficiary. Do they have capacity issues? Are they married? Are they single? Do they have children or other dependents? What's their expected life expectancy? What are their current assets? And then the big one, which Audrey's going to touch on, which is the issue of the choice of trustee. and alternate trustees?
Thanks, Ken. So when we started a conversation with a client about their estate plan, often the thing that takes maybe 75% or just like a really large chunk of time, not surprisingly, is choosing a trustee. And the reason why that's such a big choice for individuals is they're appointing that person who they're really placing this, for lack of a better word, trust in to manage these funds for the beneficiary. Um, and so there's lots of issues to consider because, that beneficiary may live for 20, 40, 60 plus years. The trust may last for a really long time. So how old is that beneficiary? Like maybe that beneficiary is only 5 years old and their life expectancy is 80, 90 plus. So that could last for years. So in that case, you have to think of things like how old is the trustee? Is that trustee going to live beyond the beneficiary? They could pass away before the beneficiary. Do you have alternate trustees in mind who can step in after them? And beyond that, it doesn't have to be just one trustee. How many trustees should you have? Or should there be a provision for alternate trustees to be appointed if you don't know who those alternate trustees might be at this point? Something else that you may want to consider is the trustee doesn't always have to be somebody you know. It could be a corporate trustee, it could be a financial institution that sort of does this trustee work professionally. In that case, you don't have to worry as much about age because it's more of an organization, and you know that they're likely going to always be in existence throughout the life of the beneficiary. I think we have that note in there about the 21-year deemed disposition rule, because for most trusts, every 21 years, the trust is deemed to have disposed of all the assets in the trust and the tax has to be paid on that. The reason for this rule is that government didn't want people to be able to sort of avoid paying taxes on something if a trust was to last forever, and therefore taxes would be deferred indefinitely. So that's why we have that 21-year deemed disposition rule. Some trusts are designed so that they actually wind up before the 21 years. In our example, where we have a disabled beneficiary, that likely isn't going to be taken into as much consideration because you want that trust to last for as long as the beneficiary is alive. Number 4, if you're appointing that individual trustee, does that trustee know you and your circumstances, how you've looked after or cared for this beneficiary throughout your life? Do you trust them to be able to follow your wishes? In the case of a corporate trustee, let's say you don't have a family member or a friend who can act in this capacity, and you're looking at appointing a professional trustee. Obviously, they don't know you very well personally or your family, but something that you can do is write something called the letter of wishes. And this letter is something that's non-binding. However, it does allow you to sort of explain to your trustee your vision and your wishes that you have when you made this trust. And that explains sort of what your values are, ways that you've taken care of the beneficiary, and how you wish for them to be taken care of after you pass away as well. So that allows you to give some personalization and context to this person who will be managing the trust for the beneficiary. Some other things to consider when choosing a trustee. Do you want to have the ability to remove or replace trustees or permit them the opportunity to resign as well? And when appointing individual trustees, some people think, I might save money because I'm appointing somebody who I know personally and they won't charge the same fees as a corporate trustee. But something that people might not think of is, does that trustee have familiarity with provincial disability laws? Do they know like all these rules about unearned and earned income? Do they know the tax-related consequences of certain actions that a trustee may have to take. So often having a trustee who has knowledge around these rules and regulations sometimes can actually end up being more cost effective in the long run, especially depending on the amount of funds in the trust. Something else to be considered regarding the trustees is if it's an individual trustee, where do they live? So in the past, the residency of the trust for tax purposes was where the trustee lives. Now it's more of a control and management test. But for example, if your trustee is living in the US and they're controlling and managing the trust from there, there's a real danger that the trust will be considered a US resident for tax purposes. And there might be a lot of unintended tax consequences. So that's something to keep in mind as well. And that's also a reason why individuals, rather than appointing, let's say, a young son or daughter who might later move to another country or decide to pursue a career in another country. So instead of doing that, they may want to have that option of having a corporate trustee or another organization that you know will stay residing in the same jurisdiction as the beneficiary. Also to take into consideration as well, as I mentioned before, the size and complexity of a trust. Is it something that you know, your son or daughter is going to be able to manage for the beneficiary, or is it something that requires a bit more knowledge of investment, of trust law, of disability law in BC? Finally, there's that idea of conflict as well. Conflict of interest, for example, let's say you have two daughters, one with a disability, and you're thinking of making the daughter who doesn't have a disability the trustee. However, there might be an inherent conflict of interest where within the trust, if the daughter with a disability passes away, the trust funds goes to the other daughter. So there's that conflict of they have to act in the best interests of their sister, but at the same time, you know, those funds that aren't used ultimately end up going to them. So there's not to say that you can't do that, and you can, and not to say that you can't trust your family, because many do, but there just are those small considerations that you may not have thought of when appointing a trustee, a family or friend as a trustee. And again, that's where a corporate trustee may have a little bit of a benefit there because they don't have that type of conflict of interest.
Yeah, the issue of trustees, as Audrey has outlined, is an issue that I think most families that we work with spend a lot of sleepless nights on. Just thinking about, I use the term, what army of individuals is going to do what you do. That thought process can be very, very overwhelming. And, you know, Audrey has accurately outlined why this, you know, this issue is so important. And it's not only about planning for a trustee today. We may all have in our mind who we think the trustees should be today. But as planners, we need to also contemplate that this will and this trust that you develop may be the only will you ever get to do. And that trust that we set up might have a life of many, many years, maybe 50, maybe 60 years, if you have a young person with a disability. So not only must we have a trustee today, we need to know who that trustee is maybe 50 years from now. And we may not know who that is, but we as planners will need to have a mechanism in place to deal with succession of trustees. And so, you know, that's where a good lawyer can help you navigate some of these issues and come up with a plan, again, that meets your family's needs and is unique to, you know, your estate. I wonder if there's any questions, Karen, for
Yeah,
Audrey or I on this topic.
Yeah, I actually do have a couple of questions here, Ken and Audrey. One question is, my mother put in my sister's discretionary trust that when my sister dies, the money would go with her nieces and nephews. Is this not legal?
I'll let you take that, Audrey.
Oh, sorry, I was on mute. Sorry about that. So the nice thing about having a trust or creating a trust within your will is you can create a discretionary trust where somebody is, the key beneficiary that you have in mind. So, for example, your mom had a trust for your sister, and as we talked about before, you also have that ability to decide who the ultimate beneficiaries would be. So really that she could have designated the nieces and nephews, she could have designated a charity to be the ultimate beneficiaries. Um, I can't say if there's no way you could contest it because there's a lot of other factors, but at the end of the day, you are able to decide who those ultimate beneficiaries will be.
Excellent. And the other questions I have are still on the RDSP, and I see that that is coming up in the next slide. So
Yes,
I believe
it is.
that's, yeah.
So, we talked earlier about other planning tools outside of the trust. We've talked a little bit about other exempt assets, such as the $100,000 liquid assets, the ability to own a principal residence. Gifting is obviously another area which is considered an exempt. So I think the important thing to understand, though, is that if someone is gifted an amount of funds that exceeds $100,000, that initial gifting is not considered going to impact the benefits. But once the person is holding over $100,000, and this is where the ministry is a little bit unclear, that $100,000+ still needs to be preserved to avoid a loss of benefits. So that's where, looking at other exempt assets to hold amounts above 100,000 might need to be explored, whether that's a trust or this next item, and we're finally getting to it, Karen, the Registered Disability Savings Plan. And I wish we had the ability, and maybe next time we'll do this, but we'll do a poll question of how many people actually have an RDSP. I know that the numbers are increasing, and we're really happy to hear that. But a Registered Disability Savings Plan is another exempt asset that's available to individuals that, again, qualify for the federal disability tax credit. You must have that credit to open up an RDSP. And the great thing about the RDSP is that because it's more of a retirement fund, but it also provides matching grants and bonds based on the income of the person with a disability. And you're allowed to contribute up to $200,000 in the lifetime of the person receiving that or holding that RDSP. And that $200,000 is also considered exempt, so you don't lose your provincial benefits. When you turn, or when you retire, when you're 59, typically, that RDSP will then start to provide a stream of income to the person with a disability. And that income from the RDSP is also deemed exempt for provincial disability benefit purposes. So an RDSP is an amazing tool, and it's a great vehicle, to not only sort of provide protection against loss of benefits, but also to ensure that there's a pool of funds that benefits from an appreciation of investment over time. But you also get this amazing contribution from the federal government. And a good example of this is that if you have a person receiving provincial disability benefits, and they're an adult, and they start one of these plans, for up to 20 years, they can contribute, as an example, $1,500 a year, and the federal government will provide a grant of $3,500 and potentially a bond of $1,000. So that $1,500 will get you about $4,500 every year for 20 years. So your $1,500 effectively turns into $6,000 every year if you're receiving only provincial benefits and your income is below a threshold. And over 20 years, up until the age of 49, that person will have the benefit of all these federal grants and bonds, but also the time value of money. And so that can really build into a nice little investment pool when that person with a disability is, 59 and they're ready to distribute more income. I should note that the RDSP, and I'm giving a very high level overview of this, it has its own complexities. And we could probably, Audrey and I, do a session just on RDSPs that we would do for an hour or so. So I think the key point is to remember that it is another vehicle out there, aside from trusts and aside from these other exempt assets, that I think is something that every British Columbian should be considering if they're eligible for. Karen, did that answer the question on the RDSP?
We have a couple here. I'm just going to go back to them. What happens when there is no will and the person has an RDSP? Yeah,
that's a great question. Again, if those funds fall to the person that opened up the RDSP and they don't have a will, then we're back to that intestacy legislation. Now, it's a little bit more complex than that because other issues that may arise, of course, are, policyholders. Is the parent the policyholder versus the person with a disability? So a full assessment of that issue is really important. But ultimately, the intention that the RDSP belongs and the beneficiary is tied to the person with a disability. It's their asset. And that asset, there may be some issues of recapture of grants. So if you haven't held the plan long enough, typically 10 years, you may have some repayment of grant and bond. So there's a number of complexities associated with the RDSP upon death as well. But ultimately, I guess to answer the question, again, if there's no will and funds fall into the estate, then we're back to that intestacy legislation.
Right. Another question, if the person's RDSP is over $100,000, does it affect their PWD if they are left a trust?
Right. So it's a distinct asset. And again, you can hold up to 100,000 of capital contributions. So I think that's really important to understand, because if you have $200,000 in your RDSP and through great investment, you double that to 400,000, that asset is still exempt. The only limit is the capital contribution. You can only contribute up to $200,000, and that is considered an exempt asset. Appreciation of the RDSP is not considered as part of that calculation.
Lots of information here, Ken. Great. Next question. If we put in 200,000 K, do we get matching from government plus federal government money, and then it can grow inside for all the years, or can you only put a certain amount each year? So you did answer that question earlier with the amount you contribute. She's
Yeah,
stating we may be getting.
I think
we
you're
may
gonna
be
want
getting-
to maximize your grant and bond eligibility. So the downside of doing it all at once, if you put just $200,000 into that fund and then walked away, you would only get 1 year of grant and bond. So you would want to sort of spread it out, at least potentially up to 20 years if possible, so that you could get the grant and bond every year.
Right. Thank you very much, Ken. That's all we have for now.
Wonderful. And then the last item I'll touch on really, really briefly is that there is also an ability to affect what we call an RRSP or a RIF rollover. And this is where, we try to move those assets into a trust for the person with a disability. It's a very technical area, and I won't get into any details on it, but it is another opportunity to take advantage of some tax savings by possibly exploring a distribution of a registered plan and rolling it into a trust for a person with a disability. Again, assuming they meet a number of criteria as well. So those are things that are really best dealt with an individual sort of assessment by the lawyer meeting with that client to determine, the cost benefit of that sort of transaction. Obviously there are a number of tools, and as I said, for Audrey and I, it's a bit of a planner's dream. We have a lot of vehicles, and it's a great time because there are so many tools available to us to ensure that we're providing the very best for a person with a disability. And so, it's very common for us in our analysis, to consider all of these tools in some combination and not necessarily choosing one or the other.
Thank you, Ken. This has been an information-packed webinar. I'm sure that there are some things like thoughts that are racing through your minds, and you probably have millions of questions. And something that you do want to keep in mind, sort of as a takeaway, is that not all lawyers understand wills and trusts, and not all of them who do wills and trusts understand disability issues in BC. So you've got a snapshot of how complex this area can be. And one of the sort of risks, I guess, of going to a planner who can create a will for you, but they're not understanding all of the complexities of these issues, is that that may create bigger problems down the line. So we've seen examples of that where a will was done and the person drafting the will really didn't understand what they were doing. And now the will maker has passed away, and everyone's left behind with something that has created actually even more problems. And now the people left behind are having to spend quite a bit of money to try and fix the problems that were created. So it's really important to find a lawyer who understands disability issues as they relate to your estate. Something that you might want to do is take some of the concepts that we learned about in today's webinar and take them to the meeting with your lawyer. Ask them, do you know what the difference is between a discretionary and a non-discretionary trust? Do you know what the even-handed rule means? Do you know what the asset limitations are for persons with disabilities? And make sure that they understand what these issues are and the red flags and things that they have to take into consideration when they're creating an estate plan for you that won't create more problems, but will actually give you peace of mind for the future.
Yeah, so some real final words of advice here. And again, I just echoing Audrey's comments. I know this is a lot of information and it can be overwhelming, I think. And the intention is that we don't want you walking away thinking that you're experts. What we want to do is instill a bit of a foundation of knowledge to help you sort of navigate the next steps in terms of planning and ensuring that you have a bit of a foundation of knowledge when it comes to whether it's designing your plan or meeting with a lawyer to help you design that plan. You're going to have some tools that will hopefully get you to the next stage. So, we always encourage you to gather the information about your family, about your assets, about your wishes, about your potential choice of trustees, to really think about the future as well, and put yourself in the position of the planner, because our job is to contemplate the what if. What if this person can't take on that role? Who then will do it? What if that person is not alive? Where should those funds go? So think a little bit beyond today. Think about maybe 10 years, 20 years, even 50 years from now. Obviously, ensure that you don't just appoint a trustee without talking to them. Seems pretty simple. You want to make sure they're comfortable and have the ability, time, and knowledge, and capacity to take on that role. Consider your options. As Audrey's already outlined, ensure that you've got a lawyer that is experienced in this area. Don't pay somebody to learn how to do this. Make sure you find a person that has that knowledge already, and ask a lot of questions. This is a really big investment, and it's important that you get it right. It's, in my mind, no different than buying a house or choosing an investment advisor. You want to make sure that the estate plan that you design is perfect, that it considers risks, that it achieves as many of your goals as possible. So, ask a lot of questions of your advisors, and ultimately what we're trying to establish, not only about getting the planning done, but I think for many families, really getting that peace of mind to know that you've really done a good job of ensuring that your family, whether or not there's a disability, are provided for, and that you've taken steps to ensure that their unique needs are met. That, I think that concept of peace of mind, it might sound simple, but it's a huge factor for many families. And I'm sure the people here today can appreciate that, you're just trying to get that peace of mind, knowing that you haven't made any mistakes as well. So ask a lot of questions. I want to just highlight a couple of resources as well. The BC Ministry of Social Development and Poverty Reduction has a great information booklet on disability assistance and trust. I know this booklet is being updated. I don't believe it has been fully updated yet, but it's a great little resource for people that just want more of a plain language sort of overview of that interrelationship of trust and disability. Many families might be aware of PLAN as well. They're another great network to work with. And obviously, you folks have an amazing organization in FSI, led by Angela Clancy, all the way down. There's amazing people within FSI that are a great resource for knowledge. Our website as well is another great source for information. And this session, of course, is being recorded, but we have other sessions that we've facilitated for FSI that are on our website. So if any of this was sort of a blur, you can always go to the website or even the FSI website, and you can watch a session that we've done previously and do it at your own pace. On the website as well, Audrey and I have written a number of articles on this topic. So there's a number of resources that are available on our website as well. And we encourage everybody to look at both our website and even FSI's website and plan for information as well. So with that, I will thank everybody for their time. And Karen, we're quite happy to take any other questions that might be still in place.
Well, thank you so much, Ken and Audrey, for another wonderful presentation on wills and estates, recognizing that it is a lot of information. And I have watched this seminar before, and I learned something new every time I watch it. So thank you so much on behalf of FSI. Bob, not sure if you have any final words or if there's any final questions. I do have a copy of all the questions that were asked, so I will send them off to Ken and Audrey, and if they are able to answer in any further detail, that would be great. And looking forward to forthcoming sessions. Bob, back to you for final words.
Thanks so much. There is one more question that I can see. It is, how do you select a corporate trustee? What should be asking and looking for?
Yeah, that's a great question, Bob. And I find, and I think Audrey highlighted this, we're seeing more and more families consider corporate trustees, more so because of the complexity of estate planning and estate administration and that interrelationship with disability. There are a number of different corporate trustees out there. Obviously, there are the big banks. There are estate companies that provide that services. Ultimately, the determination of whether a corporate trustee is a viable option will be one of a cost-benefit analysis. And when I say that because the corporate trustees themselves will have certain asset limitations. So some corporate trustees will say, we will not administer anything under $750,000. They will also have minimum fees that are in place, with respect to administering a trust. So an analysis of trustee fees and the dollar value of the trust itself will play a role, and it should be part of the decision making as to whether it's a viable option. And obviously, for families where that trust fund, might be a relatively lower amount than what a corporate trustee is willing to take on, the risk, of course, is that a corporate trustee may not be a viable economic option. And of course, that then leaves families in a bit of a limbo because, a corporate trustee may not be an eligible sort of contributor to the plan. And this is, common when we're dealing with trust funds that are under $750,000. So, and those higher sort of targets are typically in place with the bigger banks, the private wealth groups of the big five banks. But there are also other trust-related companies that may have lower thresholds in terms of assets that they will manage, but they will also have experience in managing trusts with disability. But even those entities will have sort of ceilings on what they will and will not accept. So it's important to do your diligence. And this is where your lawyer, should be able to help you navigate some of those options and determine whether, it's a viable option for you and your family.
Thank you so much, Ken. One further comment I would like to let everybody know is I have put a survey link into the chat box. If you wouldn't mind just taking a few minutes to answer the survey. I will also be sending it out in follow-up documents tomorrow. Ken has provided us with information that we'll be able to send out to everyone, and the recording will be available at a future time. So are there any further questions for Ken or Audrey on this topic? Looks like we're good, Ken. So I'm just going to turn it back to Bob. Bob, back to you.
I'd just like to thank Ken and Audrey for this wonderful presentation. I think there was a lot of information shared, and we have a lot to think about and take away from this informative session. Thank you so much, Ken and Audrey. It's always a pleasure to have you guys on our sessions. And I would encourage other participants to get onto our FSI website and look at all the other learning explorations that we have coming up in future weeks. And I'm sure there's a lot of information in those that might also be of immense help to planning and learning other aspects of the individual's lives that we support.
Yeah,
so
thank you. Thank you, Bob. And thanks to everyone at FSI for putting this together. It's always such a pleasure and an honor to work with this team. And I see Angela there. Hello, Angela. And Angela's leadership and the great people around the table. It's an amazing opportunity, and we're always so privileged to have this opportunity to collaborate with you folks.
Great to see you, Ken, and fabulous session again. I mean, I think I've seen this session 3 or 4 times, watched the video probably more than that, and I've learned so much more again today. So as always, so welcome to have you. Thank you.
Our pleasure. Thanks.
And Audrey, thank you. This is my first time hearing you do a session with Ken, and it was just fantastic. Thank you.
Thank you so much.
We'd also like to thank all the people who have attended today. And I hope it was some help and has given you some information that is so important and valuable to all of us as parents. Thanks so much for attending today.
Have a wonderful afternoon, everyone.
Thanks, everybody. Have a good day.
Bye.